18 minutes past 7 a.m. on this Sunday morning. And we're all in the post-Christmas haze, I think. At least a lot of us are. But do we ever think about when a gift could come with some strings attached? And I need to remind you that my next interview is not intended as legal advice. You should always contact a lawyer if you need legal counsel. However, Jeff Glazer is joining us on the line. He's a lawyer with Boughton Law. Jeff, good morning to you.
Hi, how's it going?
Great. How about you?
I'm doing well, thanks.
I don't think we often think about when we receive gifts that they might come with tax strings attached or that they might bring something called Section 160 into our lives. But maybe explain a bit about how that can happen.
Okay, well, this is a section. It's right there in the Income Tax Act. And what it says is that the CRA can come and assess one taxpayer for the tax debts of a relative if that relative with tax debts of their own transferred property for free as a gift or for less than fair market value. So what it sort of was intended to come after is a scenario such as perhaps a father with a $1 million tax debt and a $1 million house in his name, transferring that house to his son to try to avoid the CRA's collection reach.
Does that happen a lot?
Well, it's the number of letters I see coming into my office and phone calls. It seems to be a section that's commonly pursued by the CRA as it's trying to enhance its collection efforts.
So if you were the receiver of something like that, should a red flag go up in that why is this person, even though they're family or a relative, why is this person suddenly giving me property or giving me a structure or something like that?
Well, it may be a natural situation where perhaps a family member, purchases a car for you or something like that, which wouldn't be in certain circumstances a strange scenario. You don't necessarily, or you don't have to have the knowledge that they owe tax debt for you to be pursued by the CRA, and the person transferring it doesn't even need to have an intention to avoid the CRA when making the gift. So it's a very common scenario where people are receiving letters from the CRA Collections Department advising them that they may or are soon to be assessed.
So it might not even be that, like you said, it might not be somebody trying to work around the tax man or trying to pull a fast one. They might legitimately be giving a vehicle or something and not know that puts the receiver on the hook as well.
Absolutely. Yeah.
That seems interesting. I mean, so if somebody does give you a car, you receive a car, you're all happy because this long lost aunt that you hadn't heard from in years is suddenly giving you a vehicle. So what should you do? Should you actually take steps when you receive the gift to make sure, or how would you even do that?
Well, it may be not a very comfortable situation when you're receiving this gift here. And let me just say for people listening that an aunt isn't necessarily related to the purposes of the Income Tax Act. Let's say it's a long-lost father or so who's come back in your life giving you a car. What can you do? I guess you can ask if they have any tax debts. There's not much more you can do to protect yourself in this situation. And it really is a situation that can come back and haunt you down the road because there is no time limit for the CRA to come after you after receiving the gift. So you may have received the vehicle, you may have used it, you may be done with it, and at that point the CRA is coming after you anyway, and you have nothing actually to sell to pay for this tax debt.
And what do you do in that case?
Well, in that case, certainly in any case that you receive this letter, usually they give you 30 days to respond before they assess you. You really should be talking to a professional, a lawyer, because there are defenses to a Section 160 assessment, and we're often able to find the facts to make out those defenses for these taxpayers.
And is it something then that somebody can't fight on their own? They actually need to get legal advice?
Well, certainly, if they're if they've got good knowledge of the law, they might be able to fight it on their own. But like most things, it could help to have a professional behind you because there are there's three basic defenses. I can go through those. Number one, you can look at the scenario. You can actually argue that the person who transferred you the property, the car, the house, didn't actually owe that tax or didn't actually owe that much tax. They may not have fought the tax bill themselves, but now you, in their place, are entitled to fight it, to try to reduce it or eliminate it. You can also, one of the most common defenses is that there is consideration paid. So even though it looks like a gift, maybe you were owed something by the relative. Maybe you had unpaid wages. You were working for them. Maybe you had loaned them money 20 years before, and this is their way of repaying you. So if you can show that you were owed something, it wasn't a gift given to you for nothing, that's also a defense. And a third sort of defense is the gift is not worth as much as the CRA is saying it's worth. Let's say it's the used car that comes to you, and they're saying it's worth $10,000. Well, you might try to show some evidence that no, the Blue Book value on that car is only $2,000, and that should be the maximum of what you're exposed for.
It sounds like a great big headache for receiving a gift.
It could be. It really could.
Does it matter the situation the person is in? Does the person need to be in the situation of owing taxes when they give the gift? Or if somebody gives you, say, we'll use the car example again, gives you that car and then, say, years later becomes in trouble with taxes, can it catch up with you then?
Well, it can kind of. The person has to owe taxes. Let's say they gave the gift in 2008. They have to owe taxes for 2008 or any year before that. So if they began owing taxes in 2009, that gift wouldn't get you. But the CRA can always come back and reassess people. So someone may have a clean tax assessment for 2008 when they made the gift. You receive it. And then years later, the CRA assesses or goes back, audits, reassesses the first person in respect of 2007 or 2008. Say they owed another $100,000. And suddenly you're on the hook. You're exposed for receiving that gift, even though that person didn't know they owed it at the time. The CRA didn't even think they owed the money at the time.
What do you do if you don't fight it and you just say, okay, fine, yes, I did this? What are you on the hook for?
Well, you're on the hook for the lesser of what the first person owed or the value of what you received. So if they owed $1 million and they transferred a property worth $500,000 to you, you're on the hook for $500,000 of that person's tax debt. And you're on the hook with them for it. So if they do eventually pay it off before the CRA comes collecting against you, then there's nothing more to collect against you on it.
So you got to hope that they're going to get their books in order.
Yeah, and then this brings into account a scenario that's interesting is if the first person goes bankrupt and the tax debt is effectively eliminated against them, that doesn't protect you. The CRA can still come after you, and that's a situation where many people think they're protected because even though the property is transferred to you, that first person has since gone bankrupt, and they think the tax debt's been wiped out. Well, the tax debt's been wiped out against the first person, but not against you.
So you still owe the money?
Yes.
What does it look like as far as a bill if somebody needs to get a lawyer to fight this? Are they looking at an expensive bill?
Well, most lawyers are working on hourly rates, and there's a wide range of hourly rates in the Lower Mainland here. But some cases don't need that many hours in it. The CRA Collections Department will send out these letters quite often without a full knowledge of the situation. So I've had many where they've sent it out and they see these monthly payments going from, let's say, husband to wife, and they think it's just sort of an allowance or a gift of money each month. And I'm able to show, wife was working for the husband's company. Here's your contract. Here's some more evidence of the service you provided, which were valuable services to his business. And at that point, the CRA backs off and perhaps doesn't assess. So quite often there's facts to show right away before that 30 days is up, before they issue the tax bill.
All right, good advice. Jeff, appreciate your time this morning. Thank you so much for chatting with us.
No problem. Thank you.
All right, that is Jeff Glazner. He's a lawyer with Boughton Law, and if you want to take another listen to this interview, you can check it out on the audio vault at cknw.com. It's also going to be podcast as well. We will break, and when we come back after the news headlines to the bottom of the hour, I've been looking forward to this segment probably too much. We're going to be joined by David Stansfield. He's a sommelier. He's also an independent wine consultant. And he's going to talk about best champagne, best bubbly, best sparkling wines, best wines all around. If you're looking for something a little bit special for New Year's Eve, or you just want something good for 2015, we will talk about that coming up right here on The Jill Bennett Show.